I'm Mark Solomon, criminal defense attorney, and I'm here to talk to you today about DUI charges. DUI charges are usually in two parts. One is against your driver's license and the other is against you. The Department of Revenue or the Department of Motor Vehicles, they're the ones who suspend your license. The courts don't have jurisdiction over your license. Once the officer submits the evidence of alcohol intoxication to them through an express consent affidavit, your license is suspended within 7 days of that notice unless you request a hearing. What I do with prospective clients is I instruct them on how to best request that hearing. I give them the pitfalls and let them make good decisions based on fact and the risks that they have based on each one of their choices. If the test was a blood test, then the officer has to get the blood test results before he can send in the express consent notice to the Department of Revenue. Once the department gets the notice of revocation from the officer with the blood results, they send a letter to your home address with the same 7-day period where you have to request a hearing. What I do is instruct my clients to request that hearing so that we have a chance to cross-examine the police officer before my clients have to make a decision about whether or not to go to trial or accept a plea offer. So what we do is we cross-examine the police officer to test everything that's in his police report. We look in every nook and cranny in regards to the times of the driving, the times of the test. We try to figure out everything that's not in the police officer's report that he's going to testify to at trial. Sometimes good things come out in the hearing, and sometimes bad things come out in the hearing. And it's always nice to be able to get that out so that you can make a decision about going to trial, having already heard what the officer is going to testify to a jury. If you go to trial, we'll do our best to represent you at trial and get you the best possible outcome.